Government Business Notice number 6, standing in the name of Mr Yan to present the Transport Legislation Amendment Bill 2025, Serial 33.
Minister for Logistics and Infrastructure.
Thank you, Madam Speaker. Madam Speaker, I present a bill titled Transport Legislation Amendment Bill 2025, Serial 33, and table the explanatory statement. Madam Speaker, I move the bill be read a first time. Madam Speaker, I present a bill entitled the Transport Legislation Amendment Bill 2025. The purpose of the Transport Legislation Amendment Bill 2025, which I refer to from here on as the bill, is to make numerous targeted and discrete amendments to several pieces of Northern Territory road transport legislation to achieve practical advances in the operation of these laws across a variety of areas. The bill amends the following legislation and the regulations made under them: the Commercial Passenger Road Transport Act of 1991, the Motor Vehicles Act of 1949, the Public Transport Passenger Safety Act of 2008, and the Traffic Act of 1987. The Department of Logistics and Infrastructure is responsible for administering transport legislation that contributes towards achieving safe, efficient and responsive transport systems that meet our community's needs. Transport laws impact all road users and the lives of Territorians that rely on safe transport systems to travel to work, school or holiday across the Northern Territory. As transport systems evolve, transport legislation requires updating to respond to road safety risks, respond to and provide for new and emerging technologies, address local operational needs, provide for efficiency measures, align with national policy, close regulatory gaps and correct technical issues. The bill amends Territory transport legislation in the following key areas: trailer registration, abandoned vehicles, NT police enforcement options for certain unlicensed or unsupervised learner drivers, expanded sentencing options for traffic offences resulting in a licence disqualification, automated decision-making, the Commercial Passenger Vehicle Regulatory Framework, transit officer operations and other miscellaneous technical amendments to ensure that the legislation is operating as intended. Madam Speaker, Territorians elected this government to reduce crime, rebuild the economy and restore our lifestyle, and we promise to make immediate changes to give Territorians more of their time back so they can spend it enjoying our unique lifestyle, not navigating lengthy administrative processes and government red tape. As promised before we were elected, this government quickly implemented motor vehicle registry reforms to contribute to driving down costs of living and giving Territorians their lifestyle back. We implemented a temporary freeze on increases to light vehicle registration fees, a 12-month free driver's licence and a 3-year registration option for light trailers. The Department of Logistics and Infrastructure implemented the 3-year trailer registration option on a temporary basis using powers under the Motor Vehicles Act 1949 until planned amendments to legislation can be progressed. The bill makes these amendments to lock in the option for Territorians to register their light trailers, being 750 kilograms or less, for up to 3 years at a time. This change means less time organising yearly registration renewals and avoiding administrative fees and registration fee increases that would otherwise be paid each year. And for automated decision-making, Madam Speaker, the Motor Vehicles Act of 1949 has served the people of the Northern Territory well. However, it was first drafted at a time when government service delivery was entirely paper-based, much lower in volume, and when the concept of computer-based systems was not contemplated. The reality today is quite different. The MVR processes approximately 600,000 transactions each year, including 510,000 vehicle registration transactions and 56,000 driver's licence renewals. The MVR has already transformed the way it does business with industry and the community, including offering Territorians the option to access these services online. This has vastly reduced the amount of time Territorians need to spend attending MVR offices and has improved service delivery for those of us living in remote and regional areas. Territorians have demonstrated a strong preference for digital delivery of MVR services. In recent years, approximately 70% of all MVR vehicle and licensing renewal transactions were completed online. While other legislation enables or facilitates the MVR's use of digital systems, these are not integrated into the Motor Vehicles Act of 1949. As a result, the current Motor Vehicles Act 1949 does not provide a coherent or consistent basis for digital processes within its own structure. The bill amends the Motor Vehicles Act 1949 to provide updated and robust frameworks supporting current and future digital initiatives. These initiatives include the use of existing computer-based systems like MVR Online to receive and automatically process routine transactions, as well as anticipated future initiatives. Madam Speaker, the bill marks a significant milestone in the Northern Territory Government's commitment to modernising service delivery and embracing digital innovation. It is part of our commitment to giving Territorians back their time to enjoy our lifestyle. Police enforcement options for unlicensed or unsupervised drivers, Madam Speaker, are about reducing crimes, means affording Territorians the right to feel safe in our communities. For most of us, part of our day includes travelling on our roads, and we should be able to feel safe travelling throughout our community. Unfortunately, there are those amongst us that continue to make bad decisions and put lives in danger by engaging in high-risk behaviour on our roads. As most people are very aware, 2024 was a tragic year. 60 people lost their lives on Northern Territory roads, and this is unacceptable. While road safety is a whole of community responsibility, the Northern Territory Police Force plays a crucial role in enforcing our road laws. The Traffic Infringement Notice, or the TIN scheme under the Traffic Act of 1987, or the scheme, provides police with the option of issuing monetary penalties or TINs to persons allegedly caught breaching road transport laws, and a quick and efficient way to discourage risky behaviour on Territory roads. The scheme is intended to act as a deterrent against offending, whilst also providing police with a swift enforcement mechanism for dealing with alleged offenders. Police retain the option of enforcing all offences through the courts. The scheme enables police to focus their court prosecution resources on more serious offences that involve a higher risk of serious injury or death to other road users. The bill fulfils a police request to introduce 2 new TIN offences, first being a learner licence holder driving a motor vehicle without a required supervising driver, and a second, a person driving a vehicle for which they have never held a licence. In relation to licensing, disqualification, sentencing options. Madam Speaker, unfortunately there are more serious acts on our roads that command more attention than the issuing of a traffic infringement notice. The following dangerous driving behaviours are known as the Fatal 5 for very good reason. And those are speeding, drink and drug driving, not wearing a seatbelt, distraction and fatigue. Between 2020 and 2024, 6,690 drink and drug driving related offences were proven through the NT courts. That is on average 1,672 offences each year over that period. 10-year road safety data for the period 2014 to 2023 indicates alcohol is a contributing factor in at least 53% of fatalities and at least 20% of serious injuries, whilst drugs were a contributing factor in 30% of fatalities and 7% of serious injuries. In 2023, police conducted 107,714 alcohol tests, of which 7.2% of those tested were found to be exceeding 0.05 blood alcohol concentration. In 2022, police conducted 1,119 drug tests on drivers on Territory roads, and 16.2% of those drivers tested positive to a prescribed drug in their system. This is a serious problem and things need to change. Under the Towards Zero Road Safety Action Plan of 2024 to 2028, this government is focused on reviewing penalties and enforcement measures for repeat and high-risk offenders. This includes reviewing the framework behind the enforcement of drink and drug driving laws. We will look at the testing and analysis of alcohol and drugs and the adequacy of penalties for drivers who are found putting themselves and everyone else at risk by making the stupid decision to drive while affected by drugs or alcohol. The bill takes a small first step towards broader drink and drug driving penalty reforms by giving sentencing courts greater flexibility in how they impose licence disqualification periods for drink and drug driving offences. Currently, when a person is found guilty of a drink or drug driving offence and is already subject to a disqualification or is being sentenced for multiple offences that attract disqualification, such as drink or drug driving alongside other serious driving offences, disqualification periods are generally served concurrently. This can lead to outcomes that do not adequately reflect the seriousness or repetition of the offending conduct. The amendment enables a court to order that disqualification periods for new offences be served cumulatively rather than at the same time in circumstances where the person is already disqualified or is being sentenced for multiple disqualifying offences. This ensures that courts can more effectively structure sentencing to reflect the nature and gravity of the offences committed. Importantly, this reform promotes more proportionate and transparent sentencing in cases involving multiple or repeat offences. It ensures that the law does not inadvertently dilute consequences of serious or repeated unlawful driving behaviour. The amendment is a targeted and practical measure to enhance road safety and uphold the integrity of our driver licensing system. And transit officer operations, Madam Speaker. This government has also acted on community safety when it comes to public transport. We moved quickly to install driver safety screens in every public bus across Alice Springs and Darwin. We passed legislation for mandatory sentencing for assaulting frontline workers, including bus drivers. More recently, we announced a comprehensive bus safety reform strategy, a multi-stage plan to reduce antisocial behaviour, improve safety and enhance service delivery for passengers and drivers. We are closing problematic bus interchanges, expanding CCTV at known hotspots and providing onboard duress alarms and direct radio links to police. We are launching a new and improved NT Bus Tracker app, and we're continuing free bus travel as an interim measure to improve driver safety by eliminating the need to carry cash on board. This government wants every Territorian to feel safe when they catch a bus. And key to maintaining safety on our buses is the fantastic work our transit safety officers do under the Passenger Safety Act of 2008 to manage safety, security and comfort on our networks. In June, as part of this government's significant law and order reform, the Chief Minister announced that we will deliver stronger community safety outcomes by developing a new Police Public Safety Officer or PPSO stream. PPSOs will be deployed on the front line in NT Police uniform, operating under NT Police Command, and will be empowered to tackle antisocial behaviour head-on. Along with public housing safety officers, transit safety officer functions will transition to PPSOs, which are expected to be deployed in 2026. In the interim, however, transit safety officers will continue their important work. Antisocial behaviour on our public transports is a major problem, and despite the impending PPSO reforms, it is as important as ever to ensure that our transit officers are supported by effective powers under the Public Transport Passenger Safety Act of 2008. Transit safety officers have broad powers under this legislation to deal with antisocial and dangerous behaviour on our buses and at our bus stops and stations. These powers include the ability to direct a person to get off a bus or leave a bus stop or bus station if the person is not complying with a set of rules or behaviour prescribed under the Act. However, these powers are currently limited to circumstances when the person has already been given a direction to comply with the rules and subsequently contravenes that direction. Transit officers have told us when a person is breaking the rules, often the best course of action is to swiftly ensure the safety and comfort of drivers and passengers would be to immediately direct the person off the bus or out of the area. The bill makes a required amendment so that a transit officer has the power to do this in the first instance, rather than following the issue of a direction to follow the rules and waiting for that direction to be contravened. In addition, the Public Transport Passenger Safety Act of 2008 provides that a transit officer can possess a device that discharges oleoresin capsaicin or OC spray and under the right circumstances use that device. There are two types of OC products on the market containing different viscosity agents. One is thinner and is delivered in a cone-shaped spray. The other, referred to as gel, is thicker and is delivered in a more targeted direct stream that is less prone to wind interference and has a longer range. The gel version is more suitable for dealing with individual targets and lessens the risk of the user being affected by the agent. Amendments in 2022 to the Public Transport Passenger Safety Act of 2008 to provide for the possession and use of OC spray did not intend to limit the viscosity of the contents of the OC devices possessed and used by transit officers. To avoid any doubt that transit safety officers can possess and use the gel-type OC product, the bill amends the Public Transport Passenger Safety Act of 2008 to clarify that both products can be carried and used. Given the broad powers that transit officers possess, it is important to ensure that the officers appointed with these powers remain fit and proper to carry out their work. The Public Transport Passenger Safety Act of 2008 includes disqualifying offences that, if charged with or found guilty of, may lead to the suspension or revocation of a transit officer's appointment. The bill makes technical amendments to ensure these disqualifying offences remain consistent with the changes to relevant provisions under the Criminal Code Act of 1983. The Commercial Passenger Vehicle Regulatory Regime, Madam Speaker, or the CPV industry, provides essential services to the Northern Territory community. These services range from taxi or rideshare vehicle providing transport for Territorians going about their business, to specialised medical transport helping people attend appointments, to a coach company providing the transport to support the tourism industry that is so critical to the Territory's economy. Because Territorians and the Territory's economy relies so heavily on this industry and the industry it supports, it is crucial that locals and visitors have the confidence that the industry will provide safe, courteous and professional service. Whilst the regulatory framework under the Commercial Passenger Road Transport Act of 1991 has undergone major reform over the years, including enabling rideshare services in 2018, ongoing maintenance is required to adapt to changes and address issues identified through the daily operation of these services. The bill makes various amendments to the CPV legislation to support industry and meet community expectations by removing the requirement to establish a commercial passenger vehicle board that has been defunct since 2012 and has been replaced by other fit-for-purpose industry forums, increasing the penalty for taxi drivers overcharging for a fare so it provides a proportionate deterrent to the practice, aligning the penalties for operating a CPV or operating a communications or dispatch network without approval, aligning and clarifying the consequences for breaching the conditions of a commercial vehicle licence or a communications or dispatch network approval, ensuring that relevant requirements of approved codes of conduct apply at all times when a CPV is operated for hire or reward, transferring the forum of appeal against accreditation, licensing and related decisions from the local court to the Northern Territory Civil and Administrative Tribunal, aligning the infringement penalties for a minibus driver refusing a request to carry a passenger in a wheelchair with the equivalent offence for a taxi driver, introducing an infringement penalty for the existing offence of a rideshare driver not carrying their identity card or not producing their card when requested by an inspector, and various technical amendments to correct errors, clarify the application of the Act, update the appointing authority for testers of taxi equipment, update regulations that provide for the refund of a levy, and updates to clarify the source of existing exemption powers. These amendments will increase regulatory certainty, close gaps, ensure responses are proportionate to the conduct and provide for more efficient outcomes for the industry, passengers and the department. And for abandoned vehicles, Madam Speaker, vehicles that are left on a public street or public place for extended periods can be a safety hazard and an eyesore for the community and visitors alike. If the vehicle is not dealt with quickly, it is often prone to being stripped for parts and vandalised, potentially exacerbating the safety and visual impacts and complicating the eventual removal of that vehicle. Territorians are proud of their communities. Visible, vandalised, burned out car wrecks are an embarrassment for locals and are a shock and deterrent for visitors, harming our community pride and tourism industry. While road authorities, including the Department of Logistics and Infrastructure and local councils, do their best to deal with vehicles that are deemed to have been abandoned as quickly and as efficiently as possible under the provisions of Traffic Regulations 1999, there is room for improvement. The bill makes amendments to the Traffic Regulations of 1999 by expanding the definition of abandoned vehicles so authorities are clearly empowered to deal with vehicles causing problems on both public streets and public places, including, for example, those left on a verge or across a footpath. Reducing the time frame before a registered vehicle left in a parking area is deemed to have been abandoned from 7 days to 3 days. Expanding road authority powers to remove vehicles that cause danger, obstruction or inconvenience to pedestrians, not just drivers. Removing the outdated, expensive and slow requirement to advertise removal of a vehicle in the newspaper. Increasing the assumed value of a vehicle before it can be disposed of from $1,000 to $2,000. And enabling police and authorities to enter or cause a vehicle to be entered so that it can be moved, and providing required protections from liability for police, authorities, their agents for the entering, moving or storing of vehicles. The bill also makes consequential amendments carefully designed to ensure procedural fairness, including the provision of adequate notice and opportunity for owners to retrieve their vehicles before any disposal occurs. These amendments also require a search of the Personal Property Securities Register, or PPSR, before any disposal action and provide that net proceeds of any sale after costs are to be applied first to satisfy any valid Personal Property Securities Register interests and also enabling the vehicle owner to claim any remaining balance. And other miscellaneous amendments, Madam Speaker. An omnibus bill provides the opportunity to enact miscellaneous technical amendments to deal with issues that arise through the operational administration of legislation but are not part of any specific reform package. And the bill makes the following such amendments. Amendments to the Motor Vehicle Act of 1949 and the Traffic Act of 1987, clarifying the operation of owner-onus provisions in the case of enforcement action in respect of those offences where the driver of the vehicle is unidentified at the time when the offence is detected, to provide certainty in future potential legal proceedings. An amendment to the Motor Vehicles Act of 1949, repealing a historic provision that prevents the Registrar of Motor Vehicles from revoking their own appointments. This will remove the unwieldy and time-consuming process to seek approvals from the Minister for a standard administrative function that should be exercisable by the Registrar, especially given the expansion in the numbers of appointments that has occurred since this provision was first enacted. An amendment to the Motor Vehicles Act of 1949, removing an historical power for the Registrar of Motor Vehicles to issue a licence to an underage person. This power was created in the context of an underage person requiring a licence to drive a motorised wheelchair, which is no longer considered a vehicle, and as a result, motorised wheelchairs no longer need a licence to drive. An amendment to the Motor Vehicles Act of 1949, updating wording to a clearer and inoffensive way to describe a person with a disability. And amendment to the Motor Vehicles Act of 1949 to repeal redundant provisions relating to temporary revenue raising measures used more than 20 years ago. Madam Speaker, the Transport Legislation Amendment Bill 2025 makes a raft of real, effective, practical changes to increase safety, reduce red tape and contribute to this government's mandates to reduce crime, rebuild the economy and restore our lifestyle. I'm pleased to commend this bill to honourable members and table a copy of the explanatory statement.
The question is that the bill be read a first time. Those of that opinion say aye. To the contrary, no. I think the ayes have it. The clerk.
A bill for an act to amend the Commercial Passenger Road Transport Act 1999, the Motor Vehicles Act 1949, the Public Transport Passenger Safety Act 2008, the Traffic Act 1987, and regulations made under those acts.